All right, everyone. Welcome back to the EE Live Q&A. I am Mark Holthe, a Canadian immigration lawyer, ex-immigration officer, and previous high school teacher. Welcome, and I'm glad that you're able to join me. We'll wait a few minutes for everybody to connect. This episode or release of the EE Live Q&A is being broadcast at 5 p.m. Mountain Standard Time. And it's interesting, I tried doing it a couple days ago late at night, and the lighting just wasn't very good. So I really like this time, and it doesn't require me to stay up till midnight. And when we did the last EE Live Q&A, I polled all of you people to see when the best time would be. And maybe we got our wires crossed a little bit. But I didn't find there were more people attending at 9 p.m. Mountain Standard Time on a Saturday. I didn't find there were any more people attending the live session then than there is right now. So, grateful to have you guys there. I see we've got Pretty Robin. She's connected here, giving me a thumbs up. Welcome. Where are you guys all listening from? So those who are attending, let me know where you're listening from. This EE Live Q&A session is, as always, sponsored by the Express Entry Complete Step-by-Step Guide to Doing It Yourself. However, all of you guys will probably know right now that the checkout is actually closed. So the cart is closed and you're not able to access it right now, and that's because I'm making some fantastic improvements to it. So I'm really excited about what I'm doing to the course, and I'm just making it just better and stronger. And so those that are in, you're in, that's great. But as soon as I get the updates made and completed, then I'm going to re-release it here in the coming weeks. So thanks to the Express Entry Do-It-Yourself Guide, that is the sponsor, as always, of these EE Live Q&As. Great to see we've got Berger and Ahmed. Thanks for joining. And this one was a little bit more impromptu. I didn't give all of you a lot of lead time for it. But hey, it's all good. We've got Harry from Dubai. Excellent. Actually, no, Abu Dhabi. Yes, excellent. Great to have you here with us. Where is everyone else listening from? Just let me know. All right, a couple other things while we're waiting for those comments and for people to join me. It usually takes a little bit of time for people to connect while we're getting ready to broadcast these EE Live Q&As. But I wanted to take a few seconds just to welcome all of the people that are here in Canada, as well as those that are all over the world. And as we've looked at our previous, let's just take a look and see with our Express Entry Law Facebook. Some of you are watching this as a recording on our YouTube channel. And those who are watching this as a recording on our YouTube channel, we actually have a private Facebook group that most of the vast members of our of this live audience are a part of. And so this is the Express Entry Law Facebook group. And as we look here, we have crossed over 51,154 members. So it's fantastic. But if you are watching in on a recording of this, you can actually make a request through Facebook to be added as a member of this private Express Entry group. Now, it's become pretty massive, that's for sure. But the reality is this is a great place and a resource for people who have questions. And you can see here, it's going live right now. So those of you who are a part of this, I'm super excited to have you because it's so much more enjoyable when there's live interaction with all of you. So I just wanted to share that so people can send me a request to join. Looks like we've got one person right here that wants to join. So while you're all watching, I will add them in case they want to catch up to this live session right now. All right, let's jump back, and I want to give a little bit of time for you kind people who are joining in and watching this live. So, all right. So, let's see. I'm going to just jump here to one of our first questions. And the first, as you can see in the description for this video, it covers the topics that I'm going to be addressing, and the questions that have been asked me, I'm going to be answering those, and so you can check out the details that are listed there within the title of this video. I'm going to try to do that more, just so that you guys know what we're going to be expecting. All right, so as I scroll through here, we've got Cairo, Egypt, Norway, awesome, fantastic, Kuwait. Yeah, you guys are all over the place. That's fantastic. So thanks for joining from all over. And I know it's a different time zone all over the place. So although it's the end of my day today, I know for some of you it's probably midnight or very first thing in the morning. So we've got someone, Britt, living in London. Fantastic. Welcome, Anthony. Mohammed's from Dubai. Fantastic. All right, so let's get to this. So the first question comes from Gorak. And Gorak says, "Hello, Mark. Your Facebook Live Q&A videos are really very helpful. Thanks for providing such valuable insight." Okay, now this one's a little bit interesting. And I'll be honest, Gorak, and actually, Gorak is the email address, but he goes by Yogi. So, Yogi, if you're listening in, this is in response to your question that you sent me. And I guess I should also let everybody know, if you want to send a question to be considered on these live Q&As, send me an email address right here to mholthy@stringham.ca, and in the subject line you must put EE space live space Q&A. And if you put that in there, it makes it easy for me to search, because I get hundreds and hundreds of emails. Some days I can get up to 1,000 email inquiries. And trust me, there's just me who's in this office right in here at this law firm, and I have a lot of paying clients that I work for during the day, and so it's really hard to get responses in for everybody. But anyways, just make sure that you put this in the subject line, EE Live Q&A, and then you'll be set. I also, before we get to the first question any further here with Yogi, I want to congratulate all of you who received ITAs in this round of invitations that just happened today. And so if some of you are wondering, well, how do you know where to look? How do you know where to find the actual draws? Well, if you go here, and I'm going to Google it right here just to show how easy it is to find. You just type in EE and express entry, not live Q&A, but rounds of invitations. So EE rounds of invitations, and then you'll be able to pull it up. And I will show this to you as well. And we'll just enlarge it quick. This is where you go, and you can see right here, August the 2nd, 2017, there were 3,264 invitations issued for individuals that had 441 comprehensive ranking system points or higher. So that's where this came from. And we'll jump back here. So congratulations to all of you if you received an ITA. Let me know if there's anyone listening live that received an ITA, because that's awesome. So, Pretty Robinson, Canada, fantastic. Anthony says it is pouring rain in London and it's midnight. Yes, it is. So thanks for tuning in. We've got a Columbus, Ohio. Janesh, awesome to have you join us. So great. Thanks, everybody. Okay, let's jump to this question once again. So the question is, everyone, I am a marine engineer seafarer from India. I work for 6 months in a year, followed by 6 months of unpaid vacation. So basically what Yogi is saying here is that he wants to apply for express entry, but his work schedule is 6 months on and then 6 months off. And this can apply to any area, not just Yogi's situation. It could be someone who works for eight months and then has 4 months off. Or who works for 11 months and then has 1 month off and a month off of unpaid leave. And the same thing goes for Yogi here. The 6 months is unpaid. So he says, my question is, am I eligible for express entry? And what Yogi has identified here is that the requirements for the Federal Skilled Worker Program is that you must have obtained at least 1 year of continuous skilled work experience. Now, I say 1 year, but let's jump back because I want to show you guys where to get this information. Sometimes people who are sharing things online are pretending like they have the inside track on this secret information. Well, I'm not that way. You guys have every right to access every single piece of information that I do. So I'm going to show you where to find it. So often you can just simple Google will take you to where you need to go. In Canada, it's really easy, and in particular for me, because Google already knows where I'm searching. So if I go federal skilled worker eligibility and I click on that, you could maybe add in your search EE or even Canada, or even type out express entry. That might help your search engine of Google in your country to be able to know what we're looking for. But who can apply federal skilled worker? So I'm going to enlarge this so that everybody can see. And I know we've covered this quite a bit, but I want to go back to it. So in order to qualify, these are the minimum requirements. So it has to be work experience in the same type of job as your primary NOC. So it has to be linked to one NOC. It has to be in the last 10 years. It has to be paid work. Okay? So if you're on an unpaid leave, that doesn't count. So that's one of the problems right now, Yogi. But what Yogi's getting at is that it must be at least 1 year, so 1,560 hours total, or at least 20 hours per week, continuous. So the question is, if your industry is such that you have to work 6 months on and then there's 6 months off and it's just the way it is, well, are you prejudiced? Are you prevented from qualifying and meeting the eligibility requirements of the federal skilled worker program just because your work industry, the industry in which you work, doesn't operate on a traditional full-time basis? And so the question comes up, if Yogi here, if he works for 6 months and it's full-time, in other words, at least 40 hours per week, and then he has all of that time off in the next 6 months, or let's say he even works only 30 hours a week and then he has the whole time off for those 6 months. Well, if you look at these requirements, you can work a full-time at one job and meet the 1 year, or there's an opportunity if someone only works part-time, you can work 15 hours a week for 24 months. Well, in all honesty, if you were to break it down and the 6 months on and the 6 months off in Yogi's situation, you could try to argue that, well, that's at least 15 hours a week overall spread out. And I am still employed continuously. I'm just not on active duty. So it's not like I've been terminated. So you could make those arguments, right? And that's really what Yogi is getting to. And so the question that Yogi asks is, will that intermittent work actually be acceptable and allow an individual in these types of rotational work schedules to be able to qualify for express entry? And so you can make these arguments. You can. But I want to tell you that as we've seen with express entry, unless you can satisfy 100% the specific requirements of the express entry system, then there's no guarantee that it's going to be accepted. Anyone can put whatever they want in the profile because there's a computer in the background, a software algorithm that interprets the data you put in your profile, gives you a comprehensive ranking system points, and then spits out the invitation to apply to you based on what the information that you put in. There's no human being that actually looks at the profile. There's no human being that determines who's going to get an ITA. It's the computer's algorithm. It's the software that operates within the express entry portal. It's a computer that is making the decision and not a human. So if you put something in there, if Yogi says, okay, I'm just going to say that this is equivalent to at least 15 hours a week, I have worked for 24 months, therefore I meet the eligibility requirements, and he just puts it in like that, well, the reality is you could very well get an ITA. But at the time in which you submit your electronic application for permanent residence, an officer could say, I don't agree with that interpretation. I don't. And so I can tell you, Yogi, that if I was an officer and I was interpreting the specific requirements for eligibility of the federal skilled worker program, I would not accept that work experience. And I know it's a very ruthless and a heartless position to take, because therefore anyone that's in the marine engineering and seafarer industry in India is never going to qualify for permanent residence. And some people may say, well, why are you taking that position? Why would immigration be so ruthless? There might be an officer out there that accepts it and accepts the justification. Well, maybe there is. I guess it's possible. You make your pitch and you see if an officer would give you the discretion and allow it to go forward. But I can tell you that the likelihood of that happening is extremely low. And I'll tell you why. I just got back from our national, well, it's been a couple months now, our national immigration section with the Canadian Bar Association. Our national section has an annual conference. And we invite the officers to come and to teach us and to talk to us about the various aspects of immigration. In fact, a member of the Canadian Bar Association, one of our members often sits on the panel with the government officers. And 2 years ago, I was on the panel with the express entry officers. And then this year, someone else was on the panel with them. But we asked them the question about people who are going on vacation for a month. And so if you're working in Canada, for instance, and you want to go on vacation back home for a month, often that 1 month that you're away is unpaid. And so the question was, can you count that time when you're still employed, but just on an unpaid leave towards that 1 year minimum requirement, that eligibility requirement? And the officers there at our meeting, at our conference in Toronto, said no. If it's a regular paid vacation, so, for example, I'm going to be going away in a couple weeks down to Montana to spend some time with my family. I'm going to do a little fly fishing with my son on the North Fork of the Flathead River. But we're planning a vacation. I'm going to be taking a week off from work here at the office. And if I do that, I'm still getting paid for that time. But if you are an individual who is actually in this type of a situation, but you're not being paid, so you go back to the Philippines, let's say, for a month, and it's unpaid, then you can't count that as part of your continuous employment. So unfortunately, Yogi, and I know I took a long time to go through this, my position as a Canadian immigration lawyer, and hopefully someone who knows what they're talking about, is that it's very unlikely that you would be successful. Now, I'm not saying you can't try, because there's no harm in doing it. But I think the likelihood of them accepting that is going to be extremely low. Now, I'll tell you something. There's been quite a firestorm lately over another question I'm going to address, which is proof of funds. And I dared to post on our Express Entry Law Facebook group an excerpt from an email I got back from the government asking for clarification on this issue of proof of funds. And so one of the members of our group, and you know who you are, posted this doubt, basically questioning whether or not it was legitimate, whether maybe I was just tricked by someone who was pretending to be a government officer. Well, I think we've put that to rest. But the reality is, I have the ability as an immigration representative to request questions, to send questions to the government for clarification when it's not clear within the website. And I don't really care about what the website says. I'm more concerned about what the actual regulations or the ministerial instructions say, because that's really what's important. But on occasion, there's it's unclear. And so, Yogi, with your question, what I did was I actually sent an inquiry to the immigration representative's email inbox to see what they would officially say. So I don't have an answer back, but I'll keep you posted. But I can tell you from my perspective, I'm almost 95% certain, probably 99% certain, that it's not going to work. They're ruthless, and they don't care if people can't qualify. They just want to make it as easy as possible for people to understand what the requirements are, and not even as easy as possible for individuals. The government wants to make it as easy as possible for their officers. And so because of that, they don't want to have an officer figure out if 6 months on or 6 months off is good enough, or 3 months on, and 1 month off. If that rotational basis, they don't even want to have them think about it, because it just takes too much time. And with processing times of 6 months, they don't have time to waste. And that's another reason why they end up refusing applications so quickly for the smallest error. Well, if you have a 6-month processing standard to meet, you're not going to sit on an application, send a request to you for more information, and then hold it. And then when you send the request back, try and find the file wherever it is, wherever they stored it while they were waiting for you to get back to them, and then resume processing. It's way easier to just return it as being incomplete. So I hope you guys understand that. And I get a lot of people that say, hey, should I hire an immigration lawyer or a consultant, a reputable representative? Can anyone recommend anything? And then we get 50 people who are saying, forget about it. Don't worry about it. You can do it yourself. Well, that's true. Many people can. But please, please don't just say that it's a waste of time to hire someone who knows what they're doing. Because I can tell you my inbox is full of people who have made simple mistakes, innocent mistakes, who didn't understand what they needed to do because they just read the website or they followed some person who says you don't need to hire a lawyer. Here, I'll tell you how to do it. And then they got their application refused. And then that person who was offering them advice, boo, is nowhere to be found because they were basing it on their own personal experience. And just because it worked for you doesn't mean it's going to work for someone else. I never, as an immigration lawyer, I deal with countless applications all the time of express entry applications. I file tons and tons of these things, and not once do I ever go back and rely on a past experience to dictate how I'm going to file an application now. I always go right back to the website, one, to make sure if anything has changed. And so it's quite frustrating because I can't create a precedent database where I'm just funneling through applications. I actually go back to the source every single time to make sure nothing has changed because you're counting on me to do that. Okay, so we'll leave that as it is. Lots of people are posting comments and questions. I'm going to get back to them, guys, so hang in there, okay? Hang in there. Because people have sent me these right here and have taken the time to follow my instructions and send me email inquiries, I'm gonna honor them first and give their answers first. Okay, next one is, this one is from Dev, and Dev's from India. He says, "Hi Mark, God bless you for all your good work. My wife is an Iranian passport holder, now a resident in India since our marriage 3 years ago. She's been studying in India for the last 7 years and visits her home country, Iran, once in a year for around 2 months. In her last visit, she obtained a police clearance dated January 2017, and she returned to India in April 2017. So she obtained it in January, she was there for a few months, then she came back to India. Does she need to get an additional police clearance certificate from Iran since she stayed from January till April in Iran before returning to India? Hoping to receive an ITA this month. CRS 432. Oh, Dev, close. 441 was the most recent one. Keep your fingers crossed, buddy. Okay, so the question becomes, what is about these police clearances? So how do I know if mine is still valid or if I need to get a new one? All right, let me show you. Let me teach you where to find the information, the actual source. So once again, we're going to go back to the website. And this time, I'm going to type in EE completeness check. And you could put in CIC, immigration, Canada, whatever works. But I hit enter there, and that should take you to this link, applications received on or after January 1st, 2015 for permanent residents. So this here is the site where you can go to understand what an officer uses to determine when a document is complete or when a document is valid or invalid in the case of a police clearance. So let's go down here and let's take a look. So if we go down and we scroll down to mandatory documents, you'll see police clearances is on that list. So if we expand this, our answer is found right here. So you can see here, for applicants, current country of residence. So in the case here of Deb and his wife, Iran is not her current country of residence. But if she was issuing a police clearance from India, then this would apply to her. the certificate must have been issued no more than 6 months before the submission of the EAPR. So for India, needs to be valid. And if you look at this, if they haven't yet submitted their EAPR, which of course they haven't because DEV hasn't been drawn yet, then if this police clearance was from India and it was issued in January 2017, then basically that means that it's not eligible. So if it's August already, then it's too old. So this, just to give you a little clarification there, if it's from India, then this would apply and they would actually need to get a new one. But for countries, you can see right here, in which the applicant no longer resides, police clearances must have been issued after the last time the applicant lived in that country. So basically, if you're going through this process, okay, so if you read this, so for countries in which the applicant no longer resides, the police certificate must have been issued after the last time the applicant lived in that country. So police clearances are required up front and are mandatory for each country. Some countries require the applicant to complete blah, blah, blah. They need to be scanned. In exceptional circumstances, proof of having requested it might be acceptable, but ultimately that's kind of where we're at. And so you can see here, this is interesting. If you scroll down to the bottom, and we'll look at the date. This was last updated June the 6th, 2017. And so for the longest time, and this is the issue that I have, for the longest time there was a statement that basically said, as long as the person hasn't returned back to the country since the police clearance was issued, then that police clearance continues to be valid. But you can see here, this is the government. They're crazy. Once again, they've made changes. And when I read this, in my mind, this suggests that the police clearance must have been issued after the person left. Which, what the heck is with that? Most people actually have to go there and get their police clearance in person. So I think if you were trying to interpret it as that it must have been issued after the last time the applicant lived there, well, I think you're probably safe if you were there for a few months and then you left. So I think the object is that it's recent and that when you leave the country and you haven't gone back since it was issued, then it's continued to be valid. So for example, if DEV was not issued an ITA and they had not submitted their EAPR until 3 years from now, that original Iranian police clearance would continue to be valid. So that is the only position, the only reasonable position that I would take. But if you were being very cautious and you were really nervous, then all you can do is follow what the government says expressly and specifically. So for countries in which the applicant no longer resides, the police certificate must have been issued after the last time the applicant lived in that country. So that could be interpreted literally as Deb's wife having to apply for a new one while she is here, or at least in India where she resides with her husband. But I don't think it needs to be interpreted that specifically. Okay, so there you can see how crazy immigration is and how unclear it is, right? And this section here is this is the officer's notes. This is their instruction or guideline. Okay? So I think everybody kind of gets that. So we'll leave that as it is. All right, let's jump back now to the next question. Okay. So the next question is from it looks like Isaiah, I think, as it is. It's from Isaiah. And he says, "Hi, Mark. Thanks for your effort toward enlightening members on immigration regulations. You are doing an awesome job. I've seen your videos on excluding a spouse while creating the EE profile." Okay, just to clarify, everyone, I am not excluding anyone. So I'm not counseling you to not declare your spouse. I would never, ever counsel you to do that. So just to qualify, okay? My job is to explain to you the law and the policy and the regulations. Then you guys will govern yourself accordingly. But Isaiah basically says, "I've seen your videos on excluding a spouse. I intend to understand whether this will impact the inclusion of children." So, to ask precisely, suppose, as cautioned by you, A spouse cannot be included at the time of PR application due to any change in law. Okay, well, I'm not quite sure what Deb's getting, or what Isaiah is getting at here, but can I proceed to add my son as my dependent and get PR for him? So it may look as a hypothetical question. However, my CRS, and here's the kicker, this is the real reason he's asking the question. My CRS is best without my spouse accompanying me. Further, my primary aim of immigration is to provide my son the best education possible. Okay, so leaving aside the ethics or the morality of leaving your wife in your home country, the question is, can you list your spouse as non-accompanying in your EAPR application, or, sorry, let's take it back a little bit, in your express entry profile, but yet intend to include a child later on? Well, the answer is yes. There's no restriction on doing that. If you wanted to list your wife or your husband, your spouse, as non-accompanying, you can do that. And then when the time comes for filing your electronic application for permanent residence, when you receive your ITA, you can include a dependent child. You can have them come. That's not a problem at all. And just to clarify something else, Isaiah, the last time I spoke with the officers, I specifically asked them, after they've reached the lock-in date, so when the EAPR has been filed and acknowledged as being complete, then your comprehensive ranking system points are locked in and your eligibility for the Federal Skilled Worker Program or the Canadian Experience Class or the Federal Skilled Trade Program, your eligibility for those economic programs, when that is locked in, I said, can a person say, hey, I want to change my mind and now I want to add my spouse? What is the government's position on that? And I asked the government officials about that. And the answer was, there was no restriction. You actually can do that. So Deb, if you chose not to include your spouse as an accompanying spouse when you submitted your profile and listed them as non-accompanying when you submitted your EAPR, after you've passed over that lock-in period, when your CRS points are locked in and your eligibility is locked in for the economic immigration programs, you can then notify immigration that you and your spouse have decided it's better actually that they come with you. Okay? So you can actually add them on as well as your dependent children. So the government officers acknowledged that loophole existed, but at this stage they had chosen not to deal with it or not to do anything with it. But I want to reiterate to everyone that I would never ever counsel one of my clients to do that. I think it's unethical, and I think it is a little bit of a distortion of what the government really wants to have happen. So you guys can choose to do whatever you want to do. And I know that when people are desperate to get that ITA, to have an opportunity in this awesome country of mine, and I want to show you this picture here. This is Waterton. This is where I'm going on Saturday. I'm going to hike up the side of that mountain, and there's a beautiful lake on the other side, and me and my family are going to hike up there. And we're going to do the Crypt Lake hike. And we go through a cave in the mountain side of the mountain and drop down into these beautiful lakes where there's these massive trout swimming around in there. And so that's what's here in Canada. And I know that many of you people, obviously for economic reasons and greater opportunities for you and your family, education or otherwise, would do anything to be able to do that. And that's why so many of you are taken advantage of by unscrupulous, crooked consultants and agents who exploit you, who try to sell you job offers and LMIAs and offers to be able to immigrate and make all kinds of promises to you just to get your hard-earned money and then run away and leave you defrauded. So I understand that. So you guys decide what you need to do. But this is the current policy when it comes to non-accompanying dependents. All right. Here's another question. And this one, I'm just going to reiterate it very quickly because I've talked about it time and time again. Dear Mr. Holthe, I found your videos on YouTube and decided to write a question to you. So this person is actually a YouTuber. So they're not a part of our Express Entry Law Facebook group. But this person is Arena. So Iryna, Irina. And I recommend that you do join our Express Entry Law Facebook group. So if you're listening to this, please join. So the question is, and we've already discussed this, my question concerns proof of funds. If a wife is a principal applicant and she includes her husband into EE application, may a certificate on a bank account opened to the husband's name be accepted as proof of funds in this case? Should the whole necessary LICO amount of money be kept on the account of the principal applicant, or the money could be distributed between accounts of both the principal applicant and accompanying people? Thank you for your reply in advance. And oh my goodness, this question created such a storm within our Express Entry Law Facebook group. I had people all over the place questioning me. Some were calling the call center, and the call center was telling them something different. I posted my email. We've already done a past EE Live Q&A on this topic. And my position is the funds need to be in the sole possession of the principal applicant. That's this lawyer here, Mark Holthe, Canadian immigration lawyer. That's my position, that you can't submit shared and expect that the government will accept even jointly held money with both people in the same account. Do I agree with it? No, I do not agree with it. I think it's stupid. It's ridiculous. My wife and I share everything. Our accounts are jointly held. And I've reached out to immigration and told them that this policy is stupid and ridiculous. But I'll tell you something. I learned a long time ago that they're ruthless. And there may be 85 officers out of 100. There may be 85% of the officers that will fully accept funds held in a joint account with the spouse. There might be 85%. There might be 95%. But I can tell you that if there is a rule or a directive from immigration that says only the funds must be held solely by the principal applicant, then guess what I'm going to advise my clients? 100% of the time, I'm going to advise them to move the funds over into a single account for that principal applicant. That when they are preparing, that 6 months before they even submit their EAPR application, they move those funds over to a solely held account for that principal applicant, and there is 100% degree guaranteed without any doubt that that is going to be accepted. I do not take chances. My clients pay me to give them advice so that their application is approved. They don't pay me to take chances or to go on probabilities. So all of you can decide what you want to do. But the policy, the email that came back to me and to other lawyers, I might add, specifically states that it must be held in the sole possession of the principal applicant. So you guys decide what you want to do. If there's other consultants out there, other people who it's just inconvenient to do that, then please do whatever you want to do. It's nothing to me, okay? And if you're freaking out about it, then that's fine. But understand, if you don't follow those rules and you decide to just do whatever you want and provide some other evidence and some other explanation, you are free to do that. But I personally will never advise my clients to do that. All right? Okay. We have now officially laid that proof of funds nasty question, nasty contentious issue to rest. We're done. I'm not talking about that stupid thing anymore. It is done. I wasted 3 hours of my working day at $400 an hour, which is $1,200 of billable work that I should have been doing for my firm, dealing with this issue that seemed to perceive that somehow I was out to lunch or crazy. Anyways, I won't post anything that's not accurate or founded on policy. Okay, done. I'm going to stop talking about that. Okay, last question, and this was actually listed as the first one on the list. The question was, do we need to meet the employment requirements that are listed in the NOC in order to get credit for our foreign work experience? So I'm going to jump back to my screen again. I'm going to pull up a NOC 2011, and I'm going to ask you guys that are tuning in here, tell me what your occupation is. Which occupation are you applying under? Give me an example, okay? So first person to post their NOC code. I'll use theirs as an example for this next teaching moment. So let's see who's going to list it here. Who's going to do it? Anyone. I don't care what it is. List your position, list your NOC code, your 4-digit NOC code, and I'm going to use yours as an example for this particular section. So basically, we know that in order to get qualified for your work experience, okay, here we go, customer service supervisor. Okay, Cynthia, do you know your NOC code? Okay, let's take a look here and let's see if we can find this. All right, so search customer service supervisor. I think it's retail trade supervisor. Retail sales supervisor. I think that's it. Okay, so we'll operate with that one. And I'm going to blow this up so everybody can see. You don't want to look at my ugly mug. All right, so let's blow this up. So retail sales supervisors. So if we scroll down here, in order to get credit for foreign work experience and to know that you've got the right NOC code, you have to follow the regulations, the ministerial instructions as to what constitutes skilled work experience. So I know in the ministerial instructions, and I've just pulled them up here, that in order to get points for skilled work experience, you can go through here, and I'm just going to pull this up. And I think I was maybe scrolling through here, so I better find it. Okay. So foreign work experience, this is where it comes. And I'm going to make this even bigger so that everybody on their handhelds can see this. So this is the regulations, and this is listed in a number of different sections, but this is really what it's about. So it needs to be acquired by the foreign national outside Canada. It needs to be at skill level A, B, or skill type 0. It must be full-time work experience or the equivalent in part-time. It must be acquired within the 10 years. Do you see where this is coming from? Those instructions on the IRCC website are just dumbing down essentially the regulations so that everybody can understand them. And it must be paid commission. Then you go down here, and then you must specify your 4-digit NOC code. So that's where we go back to here. And the 4-digit NOC code for retail sales supervisors is 6211. Check, we've got that. So then we go back, and it says that you must have performed the actions described in the lead statement for the occupation. So if we go back here, the lead statement is right here. So so let me just flip back here. So basically, retail sales supervisors supervise and coordinate the activities of workers in the following unit groups. They're employed by stores or other retail businesses, wholesale, that sell on a retail basis to the public. Okay, so basically that's pretty straightforward. So these activities, as we look at the ministerial instructions, you must have performed the actions described. So all of them, these actions, all right? But then it says here, as well as a substantial number of the main duties. And this is another important factor. So we look at the main duties here. So as a retail sales supervisor, these are the duties that you must perform. Now, it doesn't say all of them. In the ministerial instructions, it says right here, a substantial number. So what does substantial mean? Well, if you go to some of these other immigration forums or some of these other large outfits who pump through tons of applications, they usually use this ballpark of 75%. Well, does 75% mean substantial? Well, maybe, maybe not. They use that as their guideline. Is substantial half of these? Probably not. Is substantial maybe 60%? Well, that's probably not substantial. But anyways, so a substantial number of these. So call it what it is. 75%, fine. But you need to be able to perform a substantial number. But many people now, and this gets back to the question that that was actually asked within our Facebook group. And so this is the question that I pulled out. Someone had asked whether or not you also need to fulfill these employment requirements. So you can see here, and this is where I want to really address with you. These employment requirements form absolutely no part of this of the ministerial instructions. So you do not need to have met the employment requirements in order to qualify your work experience within Express Entry. So let's take a look at this position. Completion of secondary school is usually required. Well, anytime it says usually required, that means it's not mandatory. So even if you're coming to Canada, you don't need a high school diploma to be able to serve in this position, to be able to work in this occupation. But you'll see here previous retail sales experience as a retail salesperson or clerk, cashier, blah, blah, blah. And then here's the most important part, is required. So previous experience, it doesn't say how long, it doesn't say, what you did. All it says is as that particular occupation, retail salesperson or sales clerk. So if you were coming to work in Canada, there's very few times where someone's going to hire someone to become a supervisor when they have no experience actually doing the job themselves. So it's a no-brainer. But for the purposes of qualifying your foreign work experience for Express Entry, you do not need to provide, or you do not need to meet, I should say, the employment requirements. All right? I think everybody understands that now. See? You guys are now going to be as smart and knowledgeable as every other consultant out there or agent in India or Pakistan or Nigeria or wherever you're watching from. You know more about it now than they do because you actually went to the ministerial instructions. Most of them don't even know what the ministerial instructions are. All they know is go to the website and read the website and then cross their fingers that they get it right. And if they get it wrong and screw up your application, well, then they're smarter for the next person that comes around. But it doesn't help you who just got your application refused. Okay, I'm getting off of that soapbox. It's now time, guys. It is now time to answer your questions. So I'm not going to go back and scroll all the way back through. Ralph, I see you logged on. Ralph, awesome. I'm so happy to have you here. Hey, Ralph, tell everybody what I did for you. Post some comments on here. And maybe I'll ask you, Ralph, do you care if I share a little bit of your story about what happened with you? Because you were my success story. Just give me a thumbs up. Okay, so Ralph Hansky here. Ralph is here in Alberta with me. His family's awesome. I love them to death. They're like close friends. Ralph was not able to pass the English requirement because of a learning disability that he had. So he struggled with the writing component and actually a number of the components. But he was able to meet the minimum standard for the Canadian Experience class for speaking. And so based on the IELTS assessment, he wasn't able to pass any of the other elements. But I knew about a rule that allowed it for an alternative assessment. So basically, if it could be shown that a person, because of a learning disability, wasn't able to complete some of the elements of the test, then we could get those waived. And the first application, Ralph, you can confirm, the first application that we filed, what happened to it? It got returned because they didn't understand what we were doing. Even though we knew the policy existed, the officer who was processing the application, they returned it to us. So we didn't accept that, did we, Ralph? Heck no. We took that, we quickly refiled a new profile, and we got it approved again, another ITA, and we resubmitted. And we loaded that application completely full of every possible piece of information an officer could want. And guess what, everybody? Ralph Hansky is a permanent resident of Canada. And he's a fantastic guy and someone I'm proud to say was my client. So thanks, Ralph, for jumping on. Very cool. There's a success story. That's where you don't accept an officer's refusal and you fight. And so, fantastic, Ralph. Okay, Rika, you're back. Let's see what you got for a question. About proof of funds. No! Proof of funds. I give up. Okay, proof of funds. Let's try. Let's see what we got here. Most of it is under my name, but 8K USD is under my husband's. Can he write? I better stop this and back it up a bit. Can he write an authorization letter that I can access it as settlement funds? Thanks very much. Rika, you're killing me. you can do whatever you want to do. Okay? So it may be possible, maybe 85% of the officers that process these applications will have no problem with that. Maybe they will. They'll have no problem. And they will say, of course, couples share their funds, or couples will have funds in different accounts, but if they're both and everybody is accompanying, then of course they're going to be able to share their funds to establish themselves in Canada. That may be the case. But there might be one officer. There may be one officer that says, no, there's no guarantee, and the regulations say the principal applicant must demonstrate that they have the funds, and they could refuse it. So, Rika, you need to proceed the way you feel best. It's possible that they will have no problem with it. But for my clients, if there's any possibility, and it's the last stage, they have an ITA, they're running out of time on their EAPR, I will counsel them to move the funds over to the principal applicant's account and then provide an explanation, a statement confirming that those funds, where they came from and why they're in the account. In fact, what I will do when I submit my applications is I will actually put in my counsel submission letter that immigration, it's because of you guys that we actually did this, because of your directive saying that it couldn't be jointly held funds. So that's why we had to move over the funds, even though the families had them collectively for 2 years in their account. I will point out exactly in my submission letter why we had to do it in that stupid fashion. So there you go, Rika. Govern yourself accordingly. Good luck. Okay, Nikolai, Mark, are there any employer requirements? In other words, how does the Canadian government determine whether or not an employer is legitimate? I'm not quite sure, Nikolai, if I understand what you're getting at. Ultimately, if there's an employer who is supporting you with a job offer, and I think that's what you're getting at here, that employer has to be properly vetted through ESDC, and Service Canada is the arm of that government body, ESDC. They're the ones who administer the labor market impact assessment process. And there is an extremely rigid process that an employer has to go through in order to get that LMIA, which is used to support your permanent resident application and allows you to get the 50 points or the 200. And on that note, I also want to point out, and I was going to actually answer this as or teach everybody about this, when it comes to those job offer points, no longer does it have to be just an LMIA. It can be a job offer that comes from a person that is working in Canada under the International Mobility Program. In other words, they came through an intercompany transfer route, or as a NAFTA professional, or through another international agreement. But if they're here working on a work permit that is employer specific, in other words, a work permit that lists the name of the employer on it. So postgrad students, postgrad work permits, unfortunately don't work. Your employers, you international students, they will actually need to get an LMIA. And you will need to change your work permit to that type of a work permit, or have them go through the process of obtaining a permanent LMIA for you to support as if you weren't in Canada. But just to clarify, you don't need to have an LMIA to get it's a job offer actually accepted. But it does need to meet the specific requirements, which is an employer-specific work permit, or if you're outside of country, then that employer actually needs to have an LMIA. So the process is actually very rigid, okay? But you need to be very careful because you as an individual, Nikolai, may not know what a valid labor market impact assessment actually looks like. And in previous EE live Q&As, I actually showed you guys what a real LMIA looks like. And I blocked out the information to maintain confidentiality, but I can't remember which one it was in. And I'm not going to go back through the, probably 50 hours of previous EE live Q&As to find it. But but basically that's your issue, is knowing that if you paid someone to find you a job, in most places getting that LMIA, it is not your responsibility to pay that. Well, I should qualify that. It's illegal for you to pay the processing fees, the processing fees if you're going to get a work permit and come under an LMIA. And in many jurisdictions, it's illegal for you to pay someone to actually get a job for them. Although other provinces, Alberta, it's illegal. You can't. But the employer is the one who has to cover those costs. Okay, I get carried away kind of with giving these responses. So I want you guys to all understand, so forgive me. Okay, Orain, whenever I search for my NOC code on CSE website, I can't find it. Can you help me to locate my code for Human Services Counselor? Okay, Orain, I can't do that right here, but I'm going to show you something. And I want all of you guys to know this. I have written a lot of blogs and created other resources because people give me these questions all the time. Now, I charge a fee to walk through this with people to find their correct NOC when it's difficult. So I have people book a consultation with me at this site right here, and I'll put a link in the comments. But essentially, this is where you can go to book a consultation with me on our firm website. And you can see Billy is here as well. You can talk to either of us. There's other lawyers here and there's other people, but this is for me. This is my group because all of you are coming through and accessing my legal services traditionally through this site. So I want to track and know how many of you are actually booking consultations. So that's why we created this. But this is where you can go. This is where people go if they want me to assess their NOC to make sure it's correct. Because if you get it wrong, it's fatal. But I don't leave you guys without help. So I'll show you something. If I Google right here, the secret to finding your correct NOC, and this is how popular it is, and I hit enter, right at the top, even above Canada Visa or LinkedIn or the Canadian immigration site, all of these other ones, ironically I'm also down here too, but finding the correct NOC, this blog post right here is the one that I created to help all of you. So if I click on it, you can see I go through in painstaking detail, and I actually just updated it on June 25th here. This explains in detail exactly how you find it, all the things you have to consider, the process that I go through to determine whether or not I have got the right NOC. And so this is where I'll direct you to, and I hope that it will be helpful in assisting you to find that correct NOC, Orain. You also can book a consult, and I'm happy to help you. We can usually do it in about 30 minutes, and my consultation fee is $200 plus GST, sales tax in Alberta, which is 5%, which results in about $210. So that's the response. So good luck. All right, Nasima, if I include spouse as non-accompanying, can I sponsor her after becoming a PR? Yes, Nasima, you can. And in fact, as I went to great detail to explain, there even is the ability. I don't like to call it a loophole because it's just kind of it's trickery. But Nasima, if you choose to basically go through the process, not list your spouse as accompanying, list them as non-accompanying, and even after you submit your EAPR and list them as non-accompanying, you can add them to your application before your electronic application for permanent residence is finalized. You do have the ability to do that. You just notify the government that you've changed your mind and now you want to include them. And so that possibility does exist. But understand at any time an officer could say, wait a minute, no, we don't accept that decision and that policy no longer exists and we're not going to let you do it. So you have to understand that's a reality. And then I also wanted to say that in answer to your question here, can I sponsor after becoming a PR? 100%. There's no issues with that at all. You just have to take the time to sponsor them through the family class as a spouse. And right now, to sponsor a spouse when you're a permanent resident for immigration to Canada, spousal sponsorship is really what it is. It's under a year. It could be faster, but it's right around a year. So that's how long you have to wait. Okay. All right. Okay, Lisa. I just joined. I'm not sure if you explained about this. I worked for a company A for 6 months, but through a staffing agency as a database analyst, and then was hired permanently by the same company. I've completed my 6 months with staffing agency and 6 months with the company. Okay, this type of a situation is often a little bit tricky, but the only thing I can tell you is that you make the pitch. ultimately you're performing all of those duties, all of those services for that company. If you look at the IRCC website, and we'll go back to the completeness check site, and I'm going to blow this up again, and I'm going to show all of you. Okay, so if you go back to the completeness check and go proof of work experience, okay, so this is what you need to do. You have to provide, these are mandatory, so a reference or experience letter from the employer. So you remember, you can actually have, and if I go back, who can apply here, you can have and count an equal amount of part-time work experience, or you can, I should say in your case, full-time at more than one job. So you can, or full-time at one job, okay? So you've got all of these options that are available to you. And so you have the ability to work full-time at one job for 30 hours, an equal amount in part-time, or full-time at more than one job. And so essentially, if you wanted to use your, I think, full-time at more than one job, in even the worst case scenario, if you're working in the same position and it's with two different employers, it still works. Okay? So your situation actually will work, and you will be just fine. You can include it. You just need to make sure that you are very clearly, and let me go back to the section here, and I keep jumping back and forth, I apologize. You need to make sure that your reference letters, if from both of them, clarifies very in great detail this information. And remember, official document printed on the letterhead, and it's signed by the immediate supervisor, and includes all the positions held. So there you go. All right, and do you guys see this? Like, this is off the cuff, man. Like, I'm explaining this on the fly. All right, let's keep going down here. Okay, Mauricia. If someone is given a deportation order, can they return legally through express entry, asking for a friend who is not in the group? Well, Mauricia, okay, if someone is given a deportation order, can they return legally? Okay, all right, so we've asked that twice. Okay, so basically, when someone is removed from Canada and they've had a deportation order, they need to receive authorization to return to Canada, an ARC, from the minister's representative. And so it really comes down to whether or not they choose to approve it. And so as far as time, I'm just looking here to see how long ago it was. Well, you make the pitch, and you need that approval to be able to return. And and when it comes to permanent residence, it's case by case, depending upon the circumstances. But it's possible. You just need the person just needs to have an authorization to return to Canada. And that application needs to be made at the visa office abroad. All right. Okay, Martha, does my ESL studies in Canada count towards Canadian education? Nope, it doesn't. Unfortunately, it needs to be actual degree program. Brian, second attempt. Smiley face. Come on, give me a break here, Brian. Okay, hi Mark, thanks for helping out. What if the situation is that one would like to apply for PR, but that person is currently separated without proper annulment papers yet? So technically the wife won't be coming because of this. Can this person apply for immigration with that in mind with his dependent children? Thanks. Well, ultimately, any spouse, if they are still a spouse under the definition of Canadian immigration, in other words, you are not otherwise divorced, that spouse needs to be medically examined, and if you are legally separated, then that's a different question. But if a spouse, if you are just in the process and they're still in the picture, you still have to ensure that they are medically examined and that they have their police clearances completed. Because if not, the government will not allow you to land. And so in those circumstances, you can bring your children. There's no restrictions on them, but your spouse would also need to authorize that. So they would need to approve the children leaving your country and immigrating to Canada. And there's an authorization form that's also produced by the government to allow you to do that. So spouses are sticky. Non-accompanying spouses are even more tricky. And a non-accompanying spouse who is no longer a spouse, in other words, an ex-spouse who you are divorced from and there's children, those spouses can be real problems, or those ex-spouses who are uncooperative can be a real problem because your children still need to be medically examined, and if they're not cooperating, That's a whole different situation. It is quite painful. Okay, Rika, you're very welcome. Tipu, thumbs up, great. Patrina, hi Mark, my friend was accepted by Canada but not Quebec and was deported. Can she apply again from her country to an English province? It's federal. So a person that's deported is deported federally. Even if it's a Quebec program, it's the Canada Border Service Agency that and I apologize for talking so quickly. It's the Canada Border Service Agency that removes individuals from Canada. And in the case of your friend, it would have been a federal deportation, so they would also need to go through the ARC to get an application to return to Canada. They would need to obtain that. Okay, Lisa, working as a database analyst, 6 months through staffing agency for a company A. Okay, yes. Payroll just completed a year altogether. Am I eligible for 1 year work experience? Same situation. So if, like I indicated before, I think in those circumstances, if it's the same position, the same NOC, you're paid, everything is in place, then it would meet the minimum, in my mind, it would meet the requirements let's see here, we'll get to the right one. Who can apply? I think it meets this bottom one. Full-time at more than one job, 30 hours per week for 12 months at more than one job equals 1 year full-time. It could be this, it could be, maybe they consider it all as just one job, but at the end of the day, it doesn't matter. Just make sure that you've got the letters to support and that they meet these minimum requirements. Okay? Great question, guys. That's a good one. So people that are not listening and don't know all of these awesome questions that are being that are being asked are missing out. Okay, let's jump back to the next one. Nikolai, okay, starting to realize that it's a big deal. How much do you charge for representation? You know your stuff. Nikolai, I'm a Canadian immigration lawyer. And most people out there that are in Pakistan or India or all over the world, they say, how much do you charge? And then I tell them, and then they say, oh, you're too expensive. Well, that's fine. But if I've got 5,000 people who want to hire me, it makes no sense for me to reduce my legal fees. So it's not cheap. I charge $5,000 Canadian in legal fees to assist people with their permanent resident applications. And that includes all family members. And so that's submitting the profile. That's filing the electronic application for permanent residence. And I want everyone to understand that processing fees that the government charges, $1,040 for principal applicant for adults, really, and $150 for dependent children, those are extra. And the sales tax, I charge 5% GST, the goods and services tax here in Alberta. And so those are all extra. But those fees that you pay, you get me, not some low-level person. Charlene in my office, who's my direct assistant, she helps me in collecting information. But I'm the one reviewing. I'm the one approving. I'm the one clicking submit. So that's why I charge $5,000, and maybe Campbell Cohen's office, I don't even know what those guys charge, or those big shops probably charge less. But that's because you're getting a low-level person. So with me, it's concierge service. And the people that want to hire me at that rate, those are the people that I like to act for. But the reality is there's many people that can't afford that. And I fully understand that. That's a lot of money if you're coming from a country whose economy and the dollar is way lower than, the currency in your country is way lower than Canadian dollars. And so when it's converted, it amounts to full month's salary or more. And I understand that. That is why I created, and I'm just going to pull it up again, that's why I created this do-it-yourself guide. Now, like I said, the queue right now, the checkout queue is actually closed right now to new subscriptions because I'm making upgrades to it. But then when I reopen it, then it will be available for everyone who is looking to get my knowledge, my help at a drastically reduced rate compared to what I do for full representation. But why can I do it at a drastically reduced rate? Because thousands of people subscribe to it, literally. And so I don't need to charge $5,000 per person. But I put my heart and soul into this, so that's how people do it. All right, there you go, Nikolai. Okay, Fod, thumbs up, great. Sofiane, I have degrees in commerce and marketing, but I have no professional experience. Please tell me if I have a chance. Okay, now no professional experience, I think that means work experience. You need, at a minimum, to qualify for the Federal Skilled Worker Program. I'm going to drop back here so that everybody understands. Once again, This is how you qualify. These are the minimum requirements. And so if you want to qualify to immigrate to Canada and you're not currently living in Canada, these are the minimum requirements. You need skilled work experience. And if you do not have at least right here 1 year of skilled work experience, then you can't even get through the door. Like you can't even qualify. You won't meet the minimum eligibility. So that's a very, very bare minimum. So one of the tips that I give people, and because you guys are live, I'll share it with you. One of the tips I give people when they're considering whether or not to apply for express entry, don't rush out and get your language test and waste your money on an IELTS test. Don't go out and get your educational credentials assessed. Don't waste your time unless you at least have that 1 year of skilled work experience. Now there's other things, and probably I might create a new video upgrading it with what to do to prepare for EE. It's all contained within my express entry do-it-yourself guide, but I may just redo some of those. Okay, so Sofiane. Okay, Orain, thank you. You bet, Orain. Okay, Brian, third attempt. Third time's the charm. Okay, all right, I answered yours, Brian. Okay, Lisa, I live in Ontario. Very cool. Can you help me? Absolutely, Lisa. I help people all over the world. In Canada, it's bliss. Many clients. In fact, I just had awesome notice from one of my clients out in Vancouver, who was a postgrad student, who was really up against it because he had an LMIA and he needed that LMIA and he needed the 600 points to qualify. And we got him in the day before the government changed the job offer points from 600 down to 50. We just got him in. I was so happy. He got his ITA. He just notified me that he just landed recently. He went back home to China and then came back. And so, so super excited. I'm happy to work with anyone. And so, Lisa, if you just want to send me, just send me an email directly to mholthy@stringham.ca. And I'll know who you are and I'll respond quickly and we can get everything started. So happy to help you in any way. All right, Khalid, Parminder, Ryan, awesome thumbs up. Thanks, guys. Okay, Brian, you're killing me. You're killing me, Brian. Still hoping you'd be able to see this. Can my brother-in-law come in when he is separated currently with his wife? I don't understand. Who's the principal applicant? Is your brother the brother-in-law the principal applicant? There's nothing stopping, but his separated wife just needs to do her part. So if it's antagonistic, then he needs to work it out. But because a spouse is a spouse until they're not a spouse, and you need to make sure that if there's a legal separation, then you might be able to get outside of the non-accompanying things. But if they're not legally separated, then even in those circumstances, she would still need to be medically examined and have a police clearance completed. Otherwise, it will cause problems. Okay. RC, hi Mark, already applied. Saskatchewan Immigrant Nominee Program. Okay, last February. Unfortunately, still waiting for approval. How long to wait my application? Thanks. I have no clue. I'll be very honest. I do not file any applications through any of the provincial nominee programs. I don't, through express entry, that is. They're so volatile. The transparency is terrible. You don't know when a program is going to close. They give all this false hope. And so, in all honesty, RC, I don't. But I've got some wonderful friends, really, really good friends, who have actually brought on my Canadian Immigration podcast. And I'll just flip back here, and I'll just show you something, everybody. This Canadian Immigration podcast, I'm actually going to release a new episode shortly here. I just did one just on July the 5th with Carter Hoppy, but these episodes are on iTunes. And so I've guests that come on and I interview them, and it's all recorded, and people can listen to it on iTunes. Anyway, so Carter Hoppy here, great lawyer over in Dubai. He came on and joined me, and this is the audio, and it's awesome. It's great. So I have lots of fun with this. I use podcasting, I do video, I do all these things. I would be happy to give you a referral to one of my colleagues in Saskatchewan, to be able to answer your questions. Now, obviously, lawyers charge fees. So they would more than likely charge you for a consultation, but they could give you insight on the Saskatchewan Immigrant Nominee Program. And I actually refer people to my colleagues, and they refer people to me who are using the Alberta Immigrant Nominee Program. Okay. All right. Okay, Lisa, thanks, Mark. Live in Toronto. If you wish to apply for my expression with you, you are in Alberta. What are the charges, fees? A brief explanation would work. Thanks. I think I already explained that, Lisa. Okay, Beros says, can you please tell us if the work experience is counted based on year or hour? You have to meet 1 year. So if you accumulate 1,560 hours in 7 months because you're working like a dog and you're working 70 hours a week or 80 hours a week, which, by the way, that is my first few years of work. When I started as an articling student and worked as an associate in the national law firm in Calgary, I was working upwards of 75 to 80 hours a week when I started my practice as a lawyer. So, so you could accumulate that time at 30 hours a week. Boy, I could have accumulated that in less than 6 months. But the reality is, to meet the 1 year minimum, you have to have worked for the full year. Okay? So you don't get bonus points for working more than 30 hours. So over a 2 year period, if you worked a minimum of 60 or 70 hours a week for those years, you can't accumulate them and make them 3 years or 4 years. So if you worked for 10 months and have accumulated 1,560 hours, it won't work. You need to be working the full 1 year time. So at the minimum of 30 hours a week. All right? Brian, thank you much. The best. No problem, Brian. Okay, Rob Stark. Okay. Hi, Mark. A huge thanks for all the amazing videos. They've been a real source of support. I hope I can ask a couple of questions. Okay. All right. Let's be patient here, Rob. Okay. Let's see what we got. Would it be possible to combine different banking roles, risk management, wealth management, which have overlaps under the same NOC? Yes. So if it's all within the same NOC, yes, you can combine them. 2, my previous company closed. I was only able to get a basic confirmation of employment letter from their sister company, and they are unable to state my duties. I've lost touch with my ex-manager since years have passed since, and I live in another country. What would you suggest? Okay, in these circumstances, it happens, right? You just have to do the best you can to create or bring in other documents or other evidence to satisfy each of those components that must be provided in the reference letter. So we're going to go back again. We're going to go to the completeness check. If I didn't close it, maybe I did. Here. We're going to go back to proof of work experience, and we're going to blow this up large for you, and we're going to go right here, and we're going to read this work experience. Okay. So this is the most important information: job title, duties and responsibilities, job status, dates worked, number of work hours per week, and annual salary plus benefits. That is the information that is mandatory, as you can see right here, for each work experience declared. If you cannot get the letter because the company is closed, then you have to do whatever you can in your power to be able to respond or demonstrate that information through another source. And it's possible that an officer says, no, I'm not going to accept it. And in fact, one of the questions at my National Canadian Bar Association conference, I didn't ask it, but someone else asked. They said, well, what if the school the person graduated from is closed down? How can they get an ECA? What do they do? Do you know what the officer said? We don't care. It's not acceptable. If you can't get it because your school's closed down, that's not our problem. Then you can't get any education credit for that schooling. And the same applies for reference letters from employers. The specific rule is you need to present the reference letter in the fashion that they want it, exactly stipulating what they want. But if you don't meet those requirements, then that's where there's an element of risk. An officer may accept alternative evidence. It's possible, but they don't have to. So you have to govern yourself accordingly. All right, Theodore. Hi, Mark. During my 3.5 years as a police officer in Jamaica. Hey, Theodore. Welcome back, buddy. I spent the last 4 months of my service in Canada as a student. I came to Canada on work paid vacation for the 4 months. Then I resigned. Does this affect my foreign work experience for EE? Like I claim that 4 months experience, even though I was going to school in Canada while on vacation before resigning, I have letters to support. Ooh, this is a tricky one, Theodore. I'm just trying to wrap my mind around what you're asking. So you spent your last 4 months of your service in Canada as a student. So you came to Canada on a work paid vacation. Okay. I'll be honest, Theodore. I don't know. So basically, you're not actually performing those duties. Okay. So you're in Canada doing something else. During that time period, they may be paying you. So it's like a vacation. So when it comes to unpaid work, you can't count it because you're away. When it comes to paid, you can count it. So if you go on a holiday and it's a paid vacation, then you can still count that as time, but you're not actually working those hours. Boy, this is tough. I think you'd have a real stretch justifying that those full four months, just because they're paying you a salary, you're going to be able to count as part of your time for work experience. I think you'd be really hard pressed. And if your employer was honest and explained that the time, that 4 months you weren't actually working for the company, but you were away in school, maybe, but it's hard, Theodore. The only thing you can do is just make the pitch. I think it would be really unlikely. It would be tough. All right, Cynthia, Sean, thumbs up, awesome. Sunny, my spouse, she's working as English language instructor, applying from Nigeria. Very cool. Can she apply with family from Nigeria, couple and daughter? Sure. If she meets the requirements, she meets the eligibility, her comprehensive ranking score is high enough, yeah, she can. Sandra, will you archive the Q&A? You guys, are you not checking out the pinned post on our Express Entry Law page? Okay, all right. Good question, Sandra. I won't give you too much trouble. I had to work and look for weeks to get the same info you give in minutes. You're so awesome. Also, will your course reopen? I know it just closed. Yes, it will, and it's going to be freaking awesome. In the interim, I closed it because I want to make sure that when it's opened, it is fantastic, awesome. Okay, Sandra, in terms of the archive. So as you can see, I'm working at trying to give explanations as to what is actually contained. When I open it up like this, oh my goodness, I can't remember what everybody asks. But I'll try to list the topics because we cover so much. But I want to show you right here. We're going to go back here. I'm going to expand this. Then I'm going to go to our Facebook page. And I'm going to go to discussions. If it opens up. All right. So at the very top. Now many of you, I'll accept all these people. Maybe they want to join the live video. Okay. So we go back here and look at the very first pinned post. If you're looking on your handheld, so my phone here, if I'm to access this on my phone, I can't ever see what you guys can see. I guess you can still see me even when it's full screen, I think. Anyways, if you're on your handheld like this, and I go to my Facebook and I pull it up, the pinned post doesn't show. If you access it from your desktop, the pinned post at the top shows. And this is where Justin posted. Justin's my tech guy. This is where he posted. Oh, get out of there. Go away. This is where he posted the link where you can go and you can access all of the archived videos. So weekly live Q&As from me, and it's all here. Okay? So these are where they're all archived. Now, let's see. So we've got this. And then I'll also give you another little piece of advice. If you go into the search this group and you go EE Live Q&A and then search it, this will also pull up the past ones. Okay, do you see? Man, there's quite a few. Hey, look at this. This is awesome. See, this is May 7th. And then I think that was one of the first ones that I started. Anyways. So there you go. That's another. So those are a couple options for you, but the archives will be available All right, great. Okay, Ryan O'Connor, hi, I hope I didn't miss your explanation on proof of funds. Joint account between me, principal applicant, and my wife, accompanying spouse. I'm almost positive, Ryan, that you got that one. You got to govern yourself accordingly, buddy. I take the position with my clients that it has to be in the sole possession of the principal applicant. If it's not, then you run the risk they're not going to accept it. I advise my clients to make whatever changes they need to transfer the funds, do whatever, because those are the specific instructions that I received, including specific instructions that they will not count jointly held funds. Do I agree with it? No, I don't. I think it's stupid. Have I petitioned them to change that because it's an idiotic rule? Yes. But it is the instruction I received, so you need to decide if you want to take that risk. Okay, Ahmed, can I hire you only in the EAPR process? Heck yeah, I do everything for my clients. I give them just consults where they ask me specific questions and do it themselves. I review the profile before they submit it to make sure that they aren't missing something and that they're getting their maximum points. I assist people 100% with just reviewing their electronic application for permanent residence, and I even represent people after they've gotten their ITA, but in that context, it's in your portal and not in my portal, and so all correspondence, all incoming notifications, you have to track those because I don't get notified about them. But absolutely, I help people 100% with as much or as little as they need. And that's why I created this, to give the very lowest ability to give people all of my knowledge and help them without them, if they want to try and do it as much as they can on their own. I understand that legal services are expensive. I understand that everything is. And you need, above and beyond all of this, you guys need to have a whack of cash available in these proof of funds in order to settle in most cases. So no worries at all. Okay. Why do your fees for the step-by-step guide charged in USD? Because it's a US company that manages it for me. All right. Good question though. So it's $39 US for the step-by-step guide. And so on the Canadian side, yeah, it's a little bit more Canadian dollars in my pocket, but it's a U.S. system, so that's why I charge the Teachable site that it's hosted on is U.S., so that's why. All right, Cynthia, nice heart. Sandra, thumbs up, awesome. Brian, sorry, I thought the comments were coming down pretty fast. My apologies. No problem. Basically, what's happened is once I click on the comments, I can scroll and see within my program, so I can stop them. And then I manually scroll through them. So no problem, Brian. All right, Rika, how come I can't view anymore? It's stuck. Anybody else having issues? I hope no one is having issues. Thanks, Mark. Okay, thumbs up. If you're doing a soft landing, how long do you have to stay in Canada before you return to your own country to finalize your business before you move permanently to Canada? It usually takes about 6 weeks or so to get your new PR card. Let's take a look. So this question is for Mauricia. Okay, let's open this up. We'll go here. Everything I say, I back up, folks, so that you know it's not just me giving you my opinion. Okay, we're going to go here, CIC, processing times. We're going to go here. So after you land as a permanent resident, you're really going to want to have your permanent resident card before you go back home. So I go back here, permanent resident cards. No, I'm waiting for my first card. Processing time, 61 days. So it's about 2 months now. It's gone up a little bit. So it takes 61 days to get your new PR card. And so often I will say to my clients, stick around till you get it. It's not mandatory. If you have someone here who can collect it on your behalf and then mail it to you, that works. But I'll tell you, I just had recently a client who was renewing her PR, and she wasn't actually living in Canada. She was abroad with her Canadian citizen spouse, so she never loses her PR. But in extending her PR card, they actually asked her to come in for an interview. So they could ask for you to come. Well, rarely will they ever ask. They'll just mail it to your address. And so you'll have to give the officer your address when you come in to have the PR card mailed to. And that's usually, sometimes it will come to my office, sometimes it will go directly to the mailing address of my client. So I usually say stick around long enough to get your PR card, but once you've landed and you don't have to stay here. The permanent resident process requires that you be physically present in Canada at least 2 years in every 5-year period after you become a PR. And so if you go home to settle affairs or to wrap things up, that's totally fine. But you can't stay outside of Canada for more than 3 years. If you do, you'll lose your permanent resident status. Okay, great question. Ahmed, hello, I am a MASC student in civil engineering. Cool, awesome. This is Ahmed. Yeah, hopefully after I finish the program, would I have 1 year of Canadian experience plus my Canadian postgraduate degree? Okay, well, you have to work, right? So your Canadian work experience, you actually have to get your postgraduate work permit and then work. And so that you'll get sweet points, like awesome, for your degree as well as the Canadian work experience, and that'll put you over the top. And guaranteed, Ahmed, your English is through the roof. So you're in great shape. I don't see any reasons why you wouldn't qualify. Nasima, just a remark regarding adding spouses after EAPR submission. Okay. On the CIC website, it's mentioned that if you add your spouse as accompanying after EAPR, their score will be recalculated and may drop, unless you get married after EPR, but I'm not sure if officers do actually recalculate scores. Okay, Nasima, can you post a link to that? Okay, so I met with the officers it was in June, and that's when I spoke with them in person. So Nasima, can you post a link on the CIC website for that? Because the policy may have changed. And if that's the case, then so be it. But after the lock-in, at least prior to my discussions with them, after the lock-in date, so after you submit it, then you ask them to add someone on. So, and that was one of the things I talked to them about, was the difference between getting married and just not including your spouse. But I don't know. They might try to use that policy. I think it's all or none. But anyways, so yeah, post the link if you could. Theodore, Theodore, this is getting longer, man. With my 3.5 years experience as a police in Jamaica, 5 appointments with training, what I'm wondering is during my time in training, I did not do a lot of duties and responsibilities that's in my work experience letter. I started to perform those duties after training, but the letter I received from work said I have 3.5 years experience and they listed the duties. Would IRC count my training as part of my experience, or they wouldn't? Should I do my calculations and exclude my training, meaning I have less experience, or should I count my training into the experience even though I didn't do much of the duties at the same? You know what? This is really hard. You ask tough questions. The reality is there's no guarantee one way or another exactly how IRCC would treat that. If you look at the requirements, you need to be performing a substantial number of those duties. And if during that time period you weren't, then maybe the training that you received is in some lesser of a position. Do you know what I mean? But, ultimately, any position is going to have a period of training. So, for example, when I started as an articling student with the national law firm of Gowlings, when I started, I knew nothing. And the duties that I performed compared to what a full lawyer does and what I do now were like not even close to it. I did research. I wrote papers. I drafted memos, I did those kinds of things. I attended hearings. I followed lawyers around. And but my duties definitely weren't as expansive as when I was, really became a full practicing lawyer. So you might be okay. Even though your training didn't encompass all of the things that you did, you're probably okay. So I would probably say that you'd be fine in those circumstances. But, at the end of the day, every officer is different. Okay. Rob Stark, massive thanks for your help, Mark. Hey, no problem, Rob. I'm super happy to help. I love doing this. In fact, if more of you guys bought my guide, it would basically cover my expenses so I could spend even more time doing this. Now, with that being said, I absolutely love my law firm and I'm 100% devoted to them. So I'd have to figure out some other way to keep working here and answering all your questions. But anyways, okay, Arjun, hi, Mark. Working 4 months on and 3 months off on a ship. I get paid around the year and working since 3 years. Can show pay slips as proof the company left. Please advise if it will be counted as full 1 year continuous work so that I can apply for EE. Okay, Arjun, I'm not sure if you jumped on after, but I actually went through and answered a question very similar for Yogi. Same type of thing, time on, time off. I really am not sure. I don't think that would be included. Well, do you know what? This is a tough one, Arjun, because you are getting paid round the year. you may very well be okay. Because the questions that I asked the officer was whether paid or unpaid leave counted. And they said if it's unpaid leave, like vacation, then you're not counted. But take, for example, teachers. So in Canada, a teacher, and I was a high school teacher, they work 10 months of the year and then they have the summers off, but they're still paid. That's still counted as experience. So Arjun, I think you're actually okay. So if you're working full time, you're getting paid, but you just get 3 months off on the ship, but you're continuing to be paid, I think you're okay. Great question. Really good question. Man, these are awesome. Ryan O'Connor. Sorry, I clicked send too fast. Haha, is joint account valid? Ryan, the information I got back is that joint account is not valid. But an officer, it's up to their discretion, and an officer may accept it. But I'm advising all of my clients, even as ridiculous and as stupid as it sounds, it's absurd. All of my accounts are joint with my spouse, with my wife. Deanna and I, we share our accounts. But because of the information that I got back, the direction from the officer, I don't take any chances. I do exactly what they tell me. And if it's a real problem, then my client, as long as they're willing to assume the risk that maybe an officer won't accept it, then we'll proceed that way and we'll submit a joint account. Okay, Caroline, thanks for the thumbs up. Boy, you guys are just keep going. You know what? It's 1 hour and 35 minutes. My family actually left me today and went down to Montana, down to Whitefish, to spend some time with my mother-in-law, and they're having fun, and so I'm batching it. So it's 6:45 p.m. tonight, so I have no responsibilities. I can go out and have fun. So we're going to close this off so I can get out of the office and enjoy this free time. But don't tell my wife I said that, because she's got jobs for me at home that I have to do, namely to clean out our garage after our camping trip. Okay, so keep it a secret. All right, so I have to cut this off at some point, guys. So it is going to get cut off here with just a couple more. So forgive me if I don't get to your question. All right. Okay, so let's see. Martha, I've got yours. Okay, Mark, can the work experience letter be dated before the date the ITA is received, or would that be an issue? Not at all. No problem at all. That letter can totally be dated before. There's no issues at all. In fact, with my clients, I demand the letter before I submit my profile. And the reason I do that is because I want to know exactly what the company is going to put on that letter. There's nothing worse than getting ready to submit an EAPR, waiting for the company to give a letter, and then it comes back all different than what the applicant and my client, what my client thought they were doing. Or at least the reference letter comes back and it's all wrong or it doesn't comply. I want those letters in advance. So when we get the ITA, bam, we filed that EAPR within days. And my clients are all screaming, yeah, hooray, we got ours filed. And they get their PR fast. But yeah, no problem. In fact, it's best practice as far as I'm concerned. Okay, yeah, great question. Sandra, thank you. I didn't know about the discussions menu on Facebook. Praise to Justin as well. Heck yeah, you bet. Okay, Sophiane, I have degrees in commerce and marketing, but I have no professional experience. Please tell me if I have a chance. Okay, Sophiane, I think what you're asking is, can you qualify without work experience? You need at least 1 year of work experience. But ultimately, just to clarify again, your degrees and everything, who cares what they are? They're separate from your work experience. Your degrees do not need to match up with the work experience that you're claiming. If you work as a food service supervisor and you've got a PhD in astrophysics, who cares? You get maximum points for the PhD in astrophysics, and the food service supervisor, as long as you are working actually and performing those duties in your country, you still get full credit for that. So whether you're a food service supervisor or an astrophysicist, you get the same number of comprehensive ranking system points for the adaptability factors. So anyways, that's, yeah, no issues at all. All right, Teresa, I recently graduated university last May. Congratulations, that's awesome. I've been in a full-time job since last September, September 2016. My goal is to move to Canada to live with my current girlfriend of 4 years who is a Canadian in Nova Scotia. Cool. I've taken my IELTS, have good scores. My year mark of my full-time job is coming up. Okay, after I get an ECA, can I successfully apply for a work permit in Canada, or is there a better document for me to apply for? My end goal ultimately is to move and live in Canada. Definitely, please help me. Thank you. Okay, so girlfriend, right off the bat, why don't you get married, and she can sponsor you. That's if you're legit, like if it's a legitimate relationship, then that's what I advise many of my clients. Just get married and have your one spouse sponsor you. Your spouse sponsor you. But from the standpoint of work and coming to Canada, depending on the country that you're at, Teresa, you may just want to set up a consult with me and we can talk about those issues. You can just go to the link. You can send me an email and then we can connect. Just send it to here. And we can connect and I can go through all of those issues with you. But, depending on if you can come as a visitor, or what your plans are, spousal sponsorship is actually probably a really good route for you guys. If that's not on the cards, then your ECA and all of this, you would have to qualify independently for a work permit. So a company would need to be able to obtain a labor market impact assessment to show there's no Canadians or permanent residents to fill the job before they can hire you. But any company who's able to get an LMIA to support your job, you can come right away and work. But ultimately, it's an independent assessment. And so after you get your ECA, you don't even have to wait for an ECA. It doesn't have anything to do with anything in terms of work. That's separate. But you do need the ECA to get your comprehensive ranking system points and everything else. So hopefully that answers the question. But hey, I encourage you just to connect with me and just book a paid consultation, and I can go through everything for you and give you advice on all the options that are available. I just don't want you to limit yourself to express entry if you think that's the only option. Okay. Okay, Cynthia, out of my 2.5 years of work experience, I took a sick leave for 4 months, which automatically reduced my work experience by 4 months. My question is, hope stating a 2-year work experience won't be a problem. Do I need to explain this while applying for EE? Thanks. Okay, your sick leave, was it paid? It all comes down to that. So 2.5 years of work experience. If it's been recent, remember, we've got this whole continuous thing. If you're going through the federal skilled worker program, leave of absence, you're going to disclose it and you're probably okay because you're still continuously employed. You're just on a leave. Paid or unpaid dictates whether you can count that experience for the purposes of, the paid or unpaid is an issue. I'm assuming sick leave, often people are continue to be paid or they receive benefits. You just want to make sure that you disclose it, but it would be more than likely it would be 2 years if it's reduced. But it depends where within the 2.5 years that work experience, that sick leave actually occurred. So tough one, Cynthia. That's a tough one. All right. You know what, guys? I think I'm going to have to shut this down. I think I'm going to have to shut it down here. Thanks so much for all the questions. And those of you who didn't quite get to the questions this time, I'm probably going to do my EE Live Q&As more often at 5 o'clock p.m. than any time else. We've had a really good turnout with lots of people that have been live and asking questions. But I just found Saturday at 9 p.m. Mountain Standard Time is unbelievably inconvenient for me. And most people are watching this after the fact anyways. Like there's 3,000 people or 4,000 people that watch these after. And I know once we open it up to the world, then there's going to be tens of thousands of people that are going to be watching these videos. I think I need to do it at a time that is the most convenient for me, and right now it is, especially with the family. And in the fall, I'm going to start coaching my high school, my son's high school volleyball team. Although he's playing football, so he's actually going to go play football, American football, instead of volleyball. But I love coaching and giving back to my community, and so I volunteer as a high school volleyball coach, which is something I love to do. All right, everyone, thanks so much for tuning in. Just a quick reminder, if you have a question that you'd like to send me to be considered on future EE Live Q&As, send it to this email, mholthy@stringham.ca, and do not forget to put EE Live right here in your subject line. And that's how I'll know that it's meant for this as a general question, because if you send an email to me and say, hey, here's all of my qualifications, am I eligible for immigration? I will direct you to Charlene, who will then send you an email saying, hey, thanks for inquiring. Here's how you can set up a consult with Mark. So, and the consults are paid. All right. Thanks, everyone. I'm going to now dive off, enjoy my evening of free time. I don't even know what I'm going to do. I'm excited. And then in the coming days, I'm actually working really hard right now on upgrading the course. So thanks so much for watching. Take care, everyone.